From subsequent list for orders, item 1, CRMP 694 of 2011.
It may mention the matter, Your Lordship.
From the list or
Permission,
outside
Your
list?
Lordship. It's a fresh filing matter of 2023.
The court master doesn't give you appropriate instructions.
I asked if I can mention fresh
You
filing
need to
matter.
mention everything to the court master, and by default, all the mentioning slips are to be allowed.
I look like
Right.
only urgency. My only urgency is matter is, Your Lordship, that they are going to publish the list, Your Lordship. We have also made a prayer for stay. So I'm only praying, my Lordship, it may be listed sometime in this week, Your Lordship. It's my only prayer. I've also stated in that.
You put your date and
I'll
inform the other side.
Oblige, much obliged.
You are unnecessarily wasting the court's
I
time.
apologize, Your Lordship. I'll do it. I'll do it.
Who is there for the petitioner?
Order date
कौन सा डेट है?
ऑर्डर डेट 2022 है हो गया है.
CRMP number 694 of 2011. The matter has been listed at the instance of the office. The date of order has been wrongly mentioned as 2/2/2022 instead of 2/2/2024. Let the order be let the date of the order be read as 2/2/2024 instead of 2/2/2022. Office to carry out necessary corrections. Post this case on the prefix date.
From daily list for orders, item 30, WPS 1724 of 2023.
Who is for the parties? Passover matters will be taken up at 12 o'clock. Next.
Item 31, WPS 4885 of 2023.
Yes, are you appearing?
माय लॉर्ड सब डिफेक्टिव रिमूव हो चुका है. सीरियल 29
Which case is this? Serial number?
बंच केस में
31.
31. This is 31.
हाँ
Are you there in 31?
जी.
Item 31, WPS 4885
29
of
1
23.
to 30 में 29 है ना.
Item 31,
The defective petitions will be taken up at 12:30 na? 12:30 time.
1 p.m.
1 p.m. Yes.
Your
Yes.
Lordship, in this case, Your Lordship, I am appearing on behalf of JSS, Your Lordship. We were directed to file our reply on this one. I am seeking 1 week more time, Your Lordship, to file our reply.
You have not filed your reply. When were you directed to file?
Your Lordship, in the last occasion, Your Lordship, we were served notice. We were directed to file our reply.
Counsel for the petitioner is absent. Counsel for the respond number.
Respondent number 6, Your Lordship.
Respondent number 6. Prays for and is directed time till
1 week time is sufficient.
28 February 2024 to file a counter affidavit in the present case. Post on 27 February under the heading for admission. Admission it will come. Next.
For press filing, item 32, WPS 3644 of 2023.
Yes, petitioner.
For quashing of an
You are seeking a relief against private respondent.
Pardon?
You are seeking a relief against private respondent.
No, against the inter-college, my lord.
That's right.
Gulab Chand Prasad Agrawal.
Yes. Are they state within the meaning of Article 12?
It is affiliated to Jack, my lord, and
Affiliation is not sufficient.
and as I was instructed by my friend that it is an added school, my lord, government added school.
We do not know. It is not mentioned in your affidavit. In your petition, it is not mentioned.
So, my lord, one time may be given, I will seek instruction whether it is whether it comes under Article 12 or not. My lord. I will find it out.
Counsel for the parties are present. Counsel for the petitioner prays for and is granted time till next Tuesday,
Next.
till 20th February 2024 to file a supplementary affidavit in the present case as to how a writ petition is maintainable against the respondent number 5. Right?
Right.
Counsel for the, you are for the respondent, Jack?
No, state.
Who's for Jack? Jack is not a party here.
Jack is not the party, state is party, my lord, and is and SDO Chhatarpur,
No, Jack is
EO
not party.
Palamu, they all are.
Jack is not party. You say that it is aided by Jack.
It is government, it is affiliated by Jack, I have stated.
Affiliation is not sufficient.
So I will, if necessary, I will file counter affidavit, otherwise it will be withdrawn.
All right. Pose this case on 21st February
Yes, my lord, 21st.
under the same heading. Next.
Item 33, WPS 446 of 2023.
But there is an IA for amendment.
IU, there is no IU. There is no IU on board.
34.
Item 33.
33.
Your Lordship, this matter is related to appointment of constable, Your Lordship, that is published in year 2015, Your Lordship.
No, but you see the manner in which you have rejected her candidature,
Your Lordship, in this case, we will have to seek instruction
What
to file our
instructions?
counter affidavit.
your counter affidavit has not been filed.
No, Your Lordship, it is coming for the first time.
Petitioner absent. Counsel for the respondent number.
2, JSS.
Respondent number 2 is directed to file, to seek instructions and file a counter affidavit in the present case. The result of the petitioner, the petitioner belongs to scheduled caste category.
Yes, Your Lordship.
Scheduled caste category, and her result has been annexed as annexure 3, and it is a specific case that in spite of having obtained more marks than the cutoff, her candidature has been rejected. Counsel for the respondents had submitted that the result in the present case was published as back as in the year
2018,
2019.
18-19.
Even as per the records,
Yes,
it is
18.
2018/19.
And thereafter, Your Lordship, fresh
However,
advertisement is
just a
also-
moment, and fresh advertisement has already been issued. But if the candidature of the petitioner has been wrongly rejected, certainly the petitioner is required to be compensated. How much time do you need?
Your Lordship.
Okay. Let the counter affidavit be filed by 12th of March 24. Rejoinder, if any, by 18, post on 19th of March. If you have wrongly rejected the candidature,
He has not
We'll see that.
He has not secured the minimum qualification.
she has, it is 31.92%.
That is the qualifying.
No, qualifying was 30.
I don't that.
Item
I don't
24.
satisfy on that. But
WPS
on
4672 of
judgment,
2023.
No, not
Fiji.
this.
On
If
Fiji.
the candidature has been wrongly rejected, the
But
candidate has to.
I am not on that issue. On physical education judgment.
Oh, yes, I need. Thank you so much.
Well,
Yes,
May name alert for the second copy because my file, I brought it here and then it got misplaced.
your tattoo mark is against the circular itself.
No, no.
Of course.
The disqualification aspect is not given with respect to tattoo mark. That the entire policy I have brought on record by the IA.
No, that is the impugned order.
Yes, ma'am.
Page number
Yes,
21.
ma'am, but that cannot be a condition for disqualification as per their own guidelines.
Okay, let us see page number 56 of your IA.
Yes, ma'am. The practice of engraving tattoo in India is prevalent since the time immemorial, but it has been limited to depict the name of a religious figure invariably on inner aspect of forearm and usually on left side. On the other hand, the present young generation is considerably under the influence of Western culture, and thus the number of potential recruits wearing skin art and growing in
Are you
numbers.
reading it for the first time?
I'm sorry.
So,
I couldn't.
that is the only ground of rejection and it is specifically mentioned.
But my lord,
Counsel for the parties are present. This interlocutory application being IA number 1358 of 2024 has been filed seeking amendment of the writ petition inasmuch as the order by which the candidature of the petitioner was rejected on account of having tattoo mark on forearm salutation hand of the salutation hand. Considering the submissions of the petitioner, IA number 1358 of 2024 is allowed and is treated to be part of the main writ petition. However, during the course of hearing, the court has pointed out page number 56 of the interlocutory application to the petitioner, which clearly indicates that indicates the circumstances under which the tattoo marks can be permitted. The petitioner is not in a position to answer the query of this court today. Post this case tomorrow. Next.
But I have put the respondent, I will file the.
No counter is required. It is on the face of it. You don't need your read.
may I pray for a pass over only?
It will come tomorrow.
Tomorrow is a holiday.
You satisfied. Day after tomorrow. Supplementary list. You incorporate the amendments, will you?
Yes, ma'am.
The counsel for the petitioner shall incorporate the amendments prayed for in the main writ petition in reading during the course of the day.
Item 35, WPS 4757 of 2023.
Petitioner. Who is for the petitioner? Yes, petitioner.
Prayer for not today,
You are seeking a relief relating to 1988 and you are seeking not today.
Senior is not
Who is your senior?
Ranjan Kumar Singh.
He is not well.
Not well.
When do you want?
Knee problem उनको
When do you want?
2 weeks.
Counsel for the parties are present. नाम बताइए अपना.
Santosh Kumar Singh.
Santosh Kumar Singh for the petitioner. He submits that this matter has to be argued by Mr. Ranjan Kumar Singh,
Ranjan Kumar Singh.
who is not present, and on his ground, he prays that the matter be posted on 27th of February, 2024. The records of the case indicate that the petitioner is seeking a relief which relates to the period, to the year 2018. No, sorry, 1988. And as per Annexure 5, the records relating to the said period is not available with the respondents. Post on 27 under the same heading. And accordingly, that should be sufficient. Next.
Item 36, WPS 4827 of 2023.
Why?
I'm not ready.
You are not?
Next week will come.
You will argue the case? You are not ready? Come to page number 23. Just a moment. 73. Kindly come. Where is your brief?
नहीं, I'm not ready.
Sorry?
मैं नहीं करूँगा.
इसीलिए ब्रीफ भी नहीं लेके आए हैं. आपको पता है ये सारे प्रोसीडिंग्स रिकॉर्डेड रहते हैं. आपका क्लाइंट सुनेगा तो क्या बोलेगा आपके बारे में? What impression will he carry? It's a misconduct, not bringing the brief to the court. Isn't it?
Also,
इनको जरा दिखाइए, ब्रीफ दिखाइए. पेज नंबर 73. Your claim was rejected on 11/6/2015 by the board. But that is neither disclosed in your writ petition nor you have annexed the same in your writ petition. Right?
2 days का time.
2 days. Next Tuesday, counsel for the parties are present. Counsel for the petitioner seeks adjournment. He submits that the matter be posted on next Tuesday. Page number 73 of the writ petition has been brought to the notice of the counsel for the petitioner, and it appears that the claim of the petitioner has been rejected by Jharkhand State Housing Board by letter number 1237 dated 11/6/2015. Kindly check, is that correct?
Yes, sir.
But the same has not been brought on record by the petitioner, and it appears that this fact has not even been disclosed by the petitioner in his writ petition. Post on next Tuesday under the same heading. Next.
Item 37, WPS 4936 of 2023.
Petitioner. Pass on. Next.
Item 38, WPS 5753 of 2023.
Petitioner.
Second half में
Second half, we have a different board.
going concern.
Yes, you have rejected the claim only on the ground of.
She's a married daughter.
It's a covered matter.
No, minute the LPA is still pending.
No, the LPA is pending. That is one thing. We do not know.
Let me file counter affidavit. It is coming for the person.
Judge, a compassionate appointment वाला दीजिए sir. Counsel for the parties are present. The matter relates to compassionate appointment, and the only ground of rejection, as is apparent from the impugned order, is that the petitioner is a married daughter. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case. ये SLP में इसका डिसमिस हो गया था ना, इसका SLP डिसमिस हो गया था, वो यीशु को पता होगा. ये छत्तीसगढ़ वाले ऑर्डर का SLP डिसमिस हो गया था ना,
Relating to a married couple, yes.
right? The counter affidavit to be filed by the respondents should take care of the fact that in judgment passed by the Honorable Chhattisgarh High Court, reported in 2022 SCC online CHH 1933, dated 21/10/2022, this is not and also the various orders passed by this court from time to
Could I
time.
name of the parties?
Name of Southeastern Coalfields Limited
Yes.
versus Shobha Parida and another.
Yes.
I think there is one more judgment wherein that clause has been said to be arbitrary,
Yes.
and then that order has been upheld by the Honorable Supreme Court. While signing this order, I'll put that if I'm able to get hold of that. But this is the view of the Honorable Supreme Court, right? I will put it in the order.
Yes.
How much time do you need?
4 weeks.
Let the counter affidavit be filed by 12th March, post on 13th March under the heading for under the heading for admission.
Recently, another division bench judgment has come of this Chhattisgarh High Court, which says you check the dependency of the married daughter.
Certainly.
You can check.
You have not checked the dependency,
Yes.
no?
Straight away we have rejected it.
Straight away you have rejected it. So first hurdle is whether a married daughter would be entitled,
Yes.
and second, whether she is dependent or not.
At the
But
time
you have
of-
rejected it at the threshold.
Yes.
So we are not going to straight away ask you to give compassionate appointment. We will certainly ask you to figure out the dependency of the married daughter.
Whether she was dependent.
Do you want that?
not today. After
Where
court.
is that order? I think we have done it with Honorable Justice.
Yes, no. I was going through the LPS which are pending. I have got that judgment. Recently, Chhattisgarh High Court has decided one of the division bench said she should be a direct dependent, therefore no dependency is required. That part has been struck down. No, married daughter would be, dependency has to be checked.
That has to be checked. Certainly it has to be checked. You are seeking too longer time.
Minutes it takes time. Already.
Okay, counsel for the respondents shall also file compilation of the various judgments passed by this court
Yes.
or other courts which the respondents would be aware of.
Yes.
Item 39, WPS 5768 of 2023.
In this case, actually, I only calling for compassion of this honorable court because, my lords, only on the ground that a date was fixed for submission of the document. My point is, my lords, that it was only published online on the website of the JSSC. It was not available anyplace else, neither through the newspaper or any other medium. So
Need not be. You submitted form online.
Yes, my lord, that was online. I had filled up.
Need not be.
And I was declared successful in the first examination. Thereafter, they had called me up for the verification of the document. I failed to go there because of my own
You can't do
difficulty.
anything about it. All these results are also published on the website.
Yes, I'm actually saying, like, if they can entertain my
You are not the solitary person, right?
only to the
No,
extent
you
that
cannot have sympathy beyond law.
no, let's I've quoted two of the judgments in this petition itself.
Which
Paragraph
judgment?
27.
Where is the advertisement? Advertisement must have said how the result is to be published.
But I was just going through. I could
कोई
not
pass over
find.
हुआ है ना? Pass over लेके.
When I was going through the advertisement, I just took a print of the entire advertisement.
Pass over दीजिए. Yes. Show it to him. This is the same advertisement.
Yes, 2016. It.
Just have a look. Correct?
Yeah.
So this matter has been passed over. You come at 12. We will decide both the cases together.
Oh. At 12.
At 12 o'clock. Pass over. Don't be absent, please.
No. I just wanted this case to be disposed of because I only mentioned this case.
Item 40, WPS 5873 of 2023.
And pursuant to the direction, we have filed a counter affidavit in this case.
Saying what?
Saying what, Malay, the prayer, initially the prayer is with respect to appointment of petitioner on the permanent post of community health officer. And its rule, framing of rules is under process, Malay. The petitioner have relied on a judgment in which the coordinate bench have already disposed of the case, Malay.
Saying what?
Saying that since the accordingly, may I read that? Accordingly, it was prayed that an application has become infructuous. He seeks permission to withdraw this application with liberty to approach the respondent number 2 for redressal of his grievances. The prayer is with respect to framing of the rules and appointment to a regular post. We are framing the rules, my lords. And so far as petitioner is concerned, they are working on a contractual post.
You just tell us one thing. The matter was remitted back by the finance department
Yes.
as back as in the year 2018 by saying that the rules are to be framed. Since 2000, so in principle you have agreeable that some rules are required to be framed,
Yes.
right? And then you will keep it pending for indefinite period of time. Your policy framed, if it remains not complied for quite some time, is it not arbitrary? Either you take a policy that it is not to be done.
It
The
is
matter
to be
will
done.
be
That
over.
is what has come in the
Right of the parties who are working is directly affected.
That is the-
So how much time will you take to frame the rules?
For that
This
we need
happened
a-
in 2018. You just seek instructions and come. How much time? How much? I will give a specific time because it cannot be indefinite.
3 weeks may be given.
3 weeks for what? For framing the rules. I will give you
I'll
right
just-
now.
One week may be given. I'll just
You just seek
apprise your
instructions.
lordship with that.
Yes, you take it on your.
That may be imposed in the. That may be like posted in the ordinance. The same thing.
Similar issue, other petition, this order has been passed.
Same.
Other council has moved, in which the detailed counter has been asked from the department.
Well, even some more cases have been filed. All these cases may be tagged if
Your
Give me
Lordship,
the
please.
list.
I'll just.
Give me the list.
I'll see.
Learned counsel for the parties are present. Counsel for the respondents has submitted that a counter affidavit has been filed in the present case,
Particularly paragraph 7 and 8.
and he has referred to paragraph 6, 7 and 8 of the counter
6, 7, 8.
affidavit. Upon perusal of the counter affidavit, it appears that the matter was initially sent to the finance department for the proposal for creation of post, but the same was wide file way back in the year 2018, but the same was returned with the advice that the post will be created after formation of rules. This happened way back in the year 2018, but as per the counter affidavit, the rule has not been framed yet. The petitioners are working on contractual basis. Considering the fact that, as per the counter affidavit, in principle, the respondents have agreed that rule is to be framed.
That is based on the guidelines of the Union of India.
Which is in turn based on based on letter dated 29th August 2022 as annexure A to the counter affidavit.
Clause 4, it is advisory to the state milord. इस लेटर को देखा जाए.
आप चुप नहीं रह सकते. आपके फेवर में ऑर्डर कर रहे हैं. Still, during the please change your habit. This is every time you are doing this. The flow of thought changes, no? Accordingly, the counsel for the respondents is directed to seek instructions regarding the time frame in which the rules are likely to be finalized. This court is of the considered view that the petitioners cannot be continued in a state of uncertainty when a policy decision has already been taken by the state for the framing of rules. At this, counsel for the petitioner has submitted that similar writ petition being WPS number 3964 of 23 is pending before this court. You also have a list?
I'll just surprise you, Lord. After consulting with the department.
Counsel for the respondents also undertake to provide a list of similar cases
if filed
pending before this court. सिर्फ 23 का number दीजिए 2020. Let all the cases be tagged and be placed on board under the heading for admission on next Wednesday.
21st. It may be taken over
21st. On next Wednesday. You will file a supplementary counter affidavit. Let the supplementary counter affidavit be filed by 19th of February.
My lords, some more time may be given since there are some holidays in between, my lords.
Supplementary counter affidavit. Let the supplementary counter affidavit be filed by 22nd February, post on 27th.
Post on?
27.
28 मिनट 27 को personal difficulty थोड़ा 28 को कर दिया.
What is personal difficulty? I have told you.
I will be outstanding.
28. How many such cases are there?
I'll just inquire with the department.
Okay. Give the list.
This has come in today, my lord.
Under the heading for admission, under the heading for final disposal to be taken up at 2:15. Next.
Item 41, WPS 5841 of 2023.
Any time for any counter.
This is the case of regulation of the computer operator, Your Lordship, as well as the extension of the service period till the regular appointment is made, Your Lordship.
You are working or not working?
My Lord,
You are working or not working? And where have you stated that you are working?
yes, I am not working, Your Lordship. After 2022, they have not extended my service.
So therefore, we cannot extend service by order of this court,
As
as you are
per-
not working as on date.
My Lord, as per memo, as per Annexure 20 units, kindly have a look to Annexure 20 units. Why they have?
Let them file a contract with WPS. How much time do you need?
My Lord, 80
WPS
lakhs,
number?
80 lakh salary is my due, Your Lordship. आज तक काम करा के पैसा
Let them
नहीं
file a
दिया।
contract with it. WPS number 5841 of 2023. You are given the details of each of the petitioners.
एक ही पिटिशनर है। हम पूरा एक्सटेंशन, लास्ट एक्सटेंशन मेरा कब तक हुआ है वो हम दे दिए। During
Please
extension
hold
period,
on.
I have been
Counsel
thrown
for
out from
the
the service.
Respondents is praised for and is granted time till 12th of March 24 to seek instructions and file a counter affidavit in the present case. Rejoinder, if any, by 19th March. Pose this case on 20th of March 24 under the heading for admission.
तीन और similar matter है उसको भी tag कर लेते हैं।
Which one? Are they on the board?
नहीं आज के board में नहीं।
You give the list.
Yes. WPS number 5418.
We'll pass an order, give the list. Give the mention slip, it will come tomorrow.
Tomorrow.
Item 42, WPS 6037.
In those cases, there is an order for counter affidavit.
No, fresh filing.
Fresh filing.
Yes.
Give the list, it will come.
Yes.
Not tomorrow, it will not come.
Was the passing of
Day after tomorrow.
Yes.
Supplementary modality. Yes.
passing of Annexure 2 and 5 by which the claim for the grant of leave encashment and gratuity has been denied to the petitioner only on account of another case which is pending before this honorable court, that is in respect to the
There is an
increment.
order of recovery, no?
No, not no.
In that
no
case,
order
there
of
is an
recovery.
order of recovery.
Yes.
We cannot ask them to make payment right now.
No, Lordship, may I say, as Lordship, they should first file a counter affidavit which they have not filed. That matter relates to increment. Recovery can be made from the retirement benefit like pension. The gratuity and the leave encashment, Lordship is knowing about all that, Jagdish Sharma and all. That is a pretext of the take a sake of the salary. It is a salary, leave encashment, and gratuity is a meritorious work which have been done. The increment which has been curtailed by them, which I have challenged, and it was state that I have, as per the Lordship's last direction on 21-24.
Counsel for the parties are present. Counsel for the respondents is directed to seek instructions and file a counter affidavit. Counsel for the respondents has referred to order dated 23/11/2022 passed in WPS number 6523 of 2022 and submits that in the same
I have
case,
annexed in supplementary
in the
affidavit,
same
Lordship.
case, the order of recovery from the petitioner is under challenge. Let this case this court is of the considered view that the present case is fit to be heard along with WPS number 3523 of 2022. Since this court is not having the roster of writ petitions of the year 2022, let this matter be placed before the Honorable Chief Justice for appropriate orders so that both the matters be heard together.
And in meantime, if they want to file court, as
They
Lordship.
will, I have already asked them to file a court.
Lordship.
Item 43, WPS 6157 of 2023.
Your Lordship, this is a matter of DGT exemption, Your Lordship, and similar matter has been had by this court, Your Lordship.
But basic foundation of the maintaining the writ application is not maintainable, Your Lordship. No details about the petitioner in the entire writ application. Therefore, writ of mandamus, no representation.
Details the petition had given, Your Lordship. Your Lordship,
बताइए.
You have the order of this court, Your Lordship.
But this may not be tagged, Your Lordship, or with badge matter. But that is creating confusion.
Your Lordship, the order. similar matter pending for this on the court also. And there are some orders, Your Lordship.
In one case, I have asked to place this matter before the Honorable Chief Justice.
Why don't I will give the number?
Where is that order?
Okay, in your temporary versus I cannot bring. That was your lordship. Why don't I will give
You just give the date. The order has been uploaded, I'm sure.
And still pending before the Your Lordship in 11th March, Your Lordship.
The date is fixed on 11th March.
11th.
There is an order. Why have you not brought the copy of the order? You please get that. You come at 2:15. We'll pass an appropriate order. There is already an order to tag the cases, right? And then the matter has been placed before the Honorable Chief Justice for appropriate order because there is one or case of 2018 also.
That's just in the time at the time argument. I've heard that that candidate which was filed case in 2018, he has passed the examination, but he has problem.
We are not concerned. There is an order to tag all these cases.
Yes.
So this case will be also tagged along with that, but there is one order which
Why
I have
not that
passed.
is your lordship kindly see WPS number 3890 of 2023.
3890 of 23.
Pawan Kumar Mandal. You देखिए तो court martial. My lord, basic foundation was also not in that date application, and thereafter the order was also passed.
It has some Supreme Court orders.
3890 of 2023.
You don't plead the foundational facts of the writ petitioners.
हम कहाँ से counter देंगे?
You don't put the foundational facts of the writ petitioner. Who are the writ petitioners? Where did they participate?
What is their roll number?
What is their roll number? Show me their roll number, please, from the writ petition.
Yes.
From the writ petition, please. No, not from annexure. You have to give the roll number of the petitioners at least in the writ petition, so that they can verify.
Subject.
Roll number, subject.
There are so many candidates, Your Lordship, and annexure 2 have given proper details.
Annexure wise, it can't be like this. It has to be there in the writ petition.
Annexure 2, Your Lordship, all the details.
Order दीजिए तो सर. Order दीजिए तो सर.
Annexure 2, Your Lordship.
Page number?
Page number 146.
This is the admit card. No, you have to give the details by filing an affidavit. They will not go through your admit cards and figure out everything.
We have given the second 147 each candidate what they have marks scored. Your Lordship. 208 marks, and they the other candidates in other districts, Pakur districts, last selected candidate 190 marks.
No, you have to put it in an affidavit. They are not going to answer to your annexures, isn't it?
Another I will find this. Each and every candidate's roll number and marks.
That is the basic
Even
for maintaining the writ application.
देखिए WPS number 6157 of 2023. Counsel for the parties are the learned counsel for the petitioner has submitted that the present case is an offshoot of the various judgments passed by Honorable Supreme Court and by this court. wherein the respondents were directed to prepare fresh merit lists for the purposes of filling up the vacancies. Soni Kumari, it is arising out of Soni Kumari. Yes.
Two orders you received.
The learned counsel for the respondents has submitted that the foundational facts with regard to the petitioners are missing in the present writ petition. He submits that as per his instructions with respect to some of the subjects, the list has already been finalized and the recommendations have already been made, but in absence of foundational fact with regard to the petitioners, no counter affidavit can be filed. The learned counsel for the petitioners you will file a supplementary affidavit.
Yes.
Is directed, petitioner submits that he shall file a supplementary affidavit in the present case, giving the details with regard to each and every petitioner in the present case. It has also been pointed out that similar matter is pending in WPS number 582 of 2023 and other analogous cases, and the next date in those cases is fixed on 11/3/2024. An order dated 7/2/2024 has been placed before this court by the respondents, passed in WPS number 3890 of 2023, wherein the said order and along with the order dated along with the order passed in WPS number 582 of 2023 and other analogous cases has been directed to be placed before the Honorable Chief Justice for appropriate orders on administrative side, as one of the cases involved in the batch is WPS number 6775 of 2018. Let this case be tagged along with WPS number 3890 of 2023. The supplementary affidavit of the petitioner be filed by next Friday. How much time do you need to give your basic details? 3 weeks. You are not keen on your case?
3 weeks.
By that time, the date in the March will also come.
Yes.
No, we will not give you so much of time. Be filed by 23rd of February 24. It will come up for admission.
On 11th March. 11th March.
No. It will come up. It will come up along with WPS number 3890 of 23. No date is being fixed because now the Honorable Chief Justice will have to pass an order and then only the matters will be posted. जैसे इसका वो आ जाएगा पता कर लीजिएगा. जैसे एडमिनिस्ट्रेटिव साइड में कोई ऑर्डर हो जाएगा, you just let us know.
Item 44, WPS 6311 of 2023.
Your Lordship, at the outset, I'm submitting that our counter affidavit is ready, praying for 1 week's time to file the same.
Learned counsel for the parties are present. Learned counsel for the respondents prays for and is allowed time till 20th February 2024 to file a counter affidavit in the present case. Post on 21st under the heading for admission.
I have got the copy of counter. I need time to rejoin.
So you have already got the copy. You file your rejoinder.
I have received, but 2 weeks time out of time.
Okay. Rejoinder by 27th February. Post on 5th of March 24 under the heading for admission.
Item 45, WPS 6919 of 2023.
The matter relates to the payment of the retirement benefits to the dependent sisters, my lord. As the petitioner, the brother of the petitioner died named Gautam Kumar Bandyopadhyay on harness on 28/3/2023. He has divorced her wife on 2001 itself and living in his father's house, and the sisters are also living along with him.
You have to seek succession certificate.
That is there.
No. It can't be like this. Brothers, sisters, they cannot have. Unless it is there in the service records, you just can't claim it.
Your Lordship is right, but they all are the.
And there is a divorced wife also. We do not know whether there is any order for payment of permanent alimony, whether that amount has been paid or not. She may have a claim of permanent alimony, isn't it? Then
Your Lordship is very right. I am completely go down before Your Lordship.
WPS number 6919
Direction
of
will be given to
2023.
prepare succession, sir.
Counsel for the parties are present. The counsel for the petitioner submits that this writ petition has been filed for the following relief, right? The counsel for the petitioner submits that the petitioner is claiming death cum retiral benefits of her deceased brother. He submits that the brother of the petitioner was married but was divorced from his wife as back as in the year 2001.
Representation is pending.
However, it is not clear from the records as to whether the divorced wife was directed to be paid any permanent alimony. And under such circumstances, no mandamus as prayed for by the petitioner. This court is not inclined to grant the relief as prayed for by the petitioner under Article 226 of the Constitution of India. At this, counsel for the respondents has submitted that the petitioner may obtain succession certificate. Considering the nature of relief sought for in the present case, it will be open to the petitioner to obtain a succession certificate and then approach the respondents for redressal of his grievances. The dismissal of this case will not be a ground to grant the relief to the petitioner if the petitioner is otherwise found entitled pursuant to any succession certificate obtained by the petitioner. That's it.
In place of dismissal, not to dispose the word may be written. It will be help to petitioner to filing the succession certificate.
No, it will not help.
Although you
When I am not inclined to issue mandamus.
Yes, although your Lordship is clear that this order will not come in the way. That's why. Obliged, Lord.
Item 46, WPS 6962 of 2023.
Counsel for the parties are present. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case by 20th February.
Lordship,
By 20th February, you will file your counter.
Lordship, 3 weeks.
By 5th of March, 24. Rejoinder, if any, by 14th of March. Post on 19th of March under the heading for revision. Next.
Item 47, WPS 7003 of 2023.
WPS number 7003 of 2023. Same order. Next.
Same one. Item 48, WPS 7006 of 2023.
Prayer of the petitioner is for the consideration of his case for appointment to the post of trained graduate teacher. My lady, my case was rejected on the ground that social sciences do not form part of the qualification that has been prescribed. Now, in the reply to RTI, it was specified, firstly, my lady, that there is a case that is pending before High Court, and only after the conclusion of that case, decision could be taken. That is mentioned to page 30. Thereafter, another RTI specific reason for my rejection, non-consideration was also given. It says at page 31, कॉमर्स विषय से डिग्री प्राप्त अभ्यर्थी की नियुक्ति नहीं की जानी है. Now, my lady, that writ petition has already been decided, in which it has been said that graduation from commerce also forms part of the social sciences subject, and it has been confirmed in division bench in LPA number 122 of the 2020. Thereafter, I have again
Graduation from commerce is equivalent to graduation in social sciences.
Yes, ma'am.
I have
That
to
is-
really find it out. Where is that? Where is that finding that this court has
Annexure.
declared that it is equivalent?
Annexure 8, page 45.
Just
In those cases, the candidate
graduation, your cases from commerce is equivalent to BCom is equivalent to BA.
social science, yes, ma'am. Page 31 is the rejection basically. Annexure 3, page 31.
Where is the finding of this court?
Annexure 8, page 45. In this case, the candidates were appointed having qualification of graduation in commerce. Page 55 is the relevant. Thereafter, they were terminated from services and they had preferred reputation. Para 12. Page 55.
Page 4 is the fact.
This is the same advertisement, page para 4.
Then what happened? Where is the finding?
Page 55.
Yes.
Page para 12. As a sequitur to the aforesaid rules of the patient's guidelines and judicial pronouncements, this court is of considered opinion that the impugned order are not sustainable in the eyes of law for the following facts and reasons. From perusal of the documents brought on record and consideration of the relevant rules of the NCPE and also subsequent amendments of the modifications, it transpires that graduates of any stream are eligible for appointment as graduate trained teachers for class 6 to class 8. In case of so-and-so, the respondent state of Jharkhand has come out with memo number so-and-so dated 28 August 2018, whereby it has been clarified that graduation degree obtained on the basis of commerce syllabus can be kept under the category of social science under the provisions of Jharkhand Primary School Teachers Appointment Rules 2012.
So these people have been appointed?
They were appointed and thereafter they were terminated. So they have again been reinstated and this has been confirmed in division bench, annexure 9, page 58. LP number 122 of the 2020. My case was held up saying that one matter is pending, that is, my lady will see annexure number 2, page 30. Annexure number 2, page 30 and annexure number 3, page 31. First, my lady will see page 31, serial number 3.
No, we'll come to that. Where is the LP order?
It starts from page number 58 and towards the end, page 66. Para 13 and para 18, page 66. At paragraph 13,
Para 13. However, in the counter affidavit.
however, in its counter affidavit filed in case number 2017, the NCT has taken stand that the petitioners who were holding not eligible for appointment under the subject advertisement, which was issued on 3rd July 2015. The affidavit filed on behalf of the NCTE has been signed by Mr. Swanso, Regional Director Swanso, but then there is no notification clarification issued by the NCTE declaring that a commerce graduate is not eligible for the appointment as assistant teacher under the social studies stream. At the same time, state of Jharkhand has not come out with any notification of the circular indicating that commerce as a subject also falls under social studies stream. In the aforesaid fluid state of affairs, there was definitely a vacuum in the field, and this created confusion in the minds of appointing authority against the writ petitioners. There is no other objection as to their eligibility and suitability for appointment as assistant teacher for class 6 to class 8 in the primary schools within the state of Jharkhand. Our attention has been drawn to the order dated so passed in contempt. Thereafter, para 18, it has been directed to frame policy. The appointment of a teacher for class 6 to 8 in the primary schools within the state of Jharkhand under the social studies stream has been raging for about a decade, but the state of Jharkhand is yet to come out with a definite policy in this regard. There is no notification issued by the NCTE.
So they have been asked to frame a policy.
Yes,
So this policy will guide the previous inductions also.
my lords, they have been retained out of the same advertisement. Now the decision has to be taken. I have preferred representation because my lady will see annexure number 2. Annexure 3, page 31. The ground of rejection. That is my lady the same.
Your candidature was rejected.
Not candidature. I participated and ultimately I was called for counseling. I was second in the merit list.
And you were selected.
And I was selected. I was called for counseling. I submitted my original certificates also.
Appointment letter issued?
No, appointment letter was not issued.
In those cases, appointment letters were issued.
Yes, appointment letter was issued.
And now the state government is still to take a policy decision.
I mean,
So even their appointment is under cloud, isn't it?
So they have to take a decision
They will
because
take a
their
decision.
services have been retained. I have preferred representation already because they say that there is a matter.
There is a difference between the two. You cannot seek appointment unless the policy decision is taken by the state.
So, ma'am, they have because
They were already in employment, therefore they have been
So,
retained.
my lords, they were granted appointment under the same status. I also share the same status. There is no.
No.
My lady, how they create a difference between what I am possessing as qualification and what they are possessing as qualification. Under same qualification, they are given
So there
appointment.
is a direction to take a policy decision. How a mandamus can be issued in absence of a policy? And this is a very recent order to take a policy decision.
So,
Passed in the when this LP order was passed on 20th February, just a
paragraph. So, my lady, I have been prompt enough. My lord. Therefore, I approached this court. It is because my case was rejected for the only reason that matter is pending before this court. Now, my lady will also see paragraph number 13. It is being said that there is no circular that regards appointment. And paragraph 18 that has been.
Counsel for the petitioner is present. Nobody appears on behalf of the respondents. This petition has been filed for the following relief. The case of the petitioner is that
My lord, in this case, NCT is wanted.
no counter is required.
No, only my appearance.
You give your appearance. The matter arises out of recruitment of assistant teacher via advertisement number 5 of 2015-16. The case of the petitioner is that the petitioner was possessing qualification of graduation in commerce and was eligible in all respects and was called for counseling, for which he appeared on 3/6/2019. But ultimately, no letter of appointment was issued to the petitioner. However, his merit position was second, bearing roll number 9550. The petitioner sought information under our right to information and was informed by letter dated 16/10/2019 that the petitioner cannot be appointed as the degree of the petitioner is under stream of commerce. The Learned Counsel has submitted that where is that letter that the matter is pending? Where is that letter?
Annexure 2.
Annexure
2, page 30.
2.
24/7. Serial number 1.
The Learned Counsel has referred to letter dated 24/7/2019 to submit that ये तो किसी और का it is addressed to Yamuna Prashad.
My letter is page 31.
So this is not communicated to you.
Similar things as well.
We do not.
Page 31, that was communicated to me.
In 31, nothing has been mentioned.
31, serial number 3, the reason for my rejection.
Yes.
That is the reason for rejection.
No, pendency of the case has not been mentioned in your communication.
In one of
The Learned Counsel has referred to Annexure 2 dated 24/7/2019 to submit that in one of the communication issued to another candidate, it was under right to information, it was referred that the matter is pending before the High Court. The Learned Counsel has submitted that the batch of writ petitions filed in the year 2017, being WPS number 963 of 2017 and other analogous cases, were decided on 12/9/2019. Arising out of the same advertisement, wherein the dismissal of, wherein inter alia, dismissal of various writ petitioners who were terminated on the ground, termination of the various writ petitioners who were terminated on the ground that they were having commerce graduate was under challenge, and their termination order was set aside by citing reasons as mentioned in paragraph 12 of the said judgment, against which LPA number 122 and of 2020 and other analogous cases have been decided by the order dated 20th February 2023 by judgment dated 20th February 2023 and the respondents have been directed to take a policy decision in the matter. He has submitted that as a consequence of the order passed in the batch of writ petition read with the latest patent appeal, the persons who were inducted in service even from the stream of commerce graduate have now continued in service. The learned counsel submits that since the petitioner is also from commerce graduate, is also a commerce graduate, and therefore appropriate relief as prayed for in this writ petition be allowed. Selection process is over.
Madam, perhaps this is covered by that Soni Kumari case, and that is perhaps it can confirm
The
that process or not.
After hearing the learned counsel for the petitioner and considering the facts and circumstances of this case, it appears that arising out of the same advertisement, a few candidates were inducted as assistant teacher, though they were commerce graduate, and soon after their induction, they were terminated from service on the ground that they were not eligible. The order of termination was challenged in WPS number 963 of 2017 and other analogous cases. And appropriate relief was granted to the said petitioners, White paragraph 12, 13 and 14, which is quoted as under. From the perusal of the said judgment, it appears that as a sequence of quashment of the impugned orders, the respondents were directed to reconsider the case of the petitioners for appointment to the post of assistant teacher in classes Roman 6 to Roman 8 under social science subject with back pages. However, when the order of the learned writ court was challenged in batch of LPA, being LPA number 122 of 2022, the Honorable Division Bench has recorded findings. The Honorable Division Bench framed issue in para 9 as follows, quote. And the findings has been recorded from paragraph 10 to 15 The Honorable Division Bench refused to condone delay in filing the LPA wide paragraph 16, and consequently the letters patent appeal were also dismissed. However, the Honorable Division Bench passed appropriate direction in paragraph 18 of the order paragraph 18, observing that made appropriate observation in paragraph 18 stating that it was expected that the state of Jharkhand shall come out with a definite policy keeping in mind the candidates who have obtained BCom degree. Paragraph 18 of the judgment passed in LPA number 122 of 2020 and other analogous cases is quoted as under. The petitioner has not placed on record the orders which might have been passed by the respondents in WPS number as a consequence of order passed in WPS number 963 of 2017 and other analogous cases. The fact remains that the Honorable Division Bench has asked the state to take a policy decision in the matter wide order dated 20th February 2023 in LPA number 122 of 2022. There is also a distinguishing fact with regard to the petitioner in as much as the petitioners in the cases decided by this court were already appointed and subsequently their appointment was cancelled. And so far as the petitioner is concerned, no letter of appointment has been issued. This court is of the considered view that the division bench having passed an order for taking a policy decision, no relief as prayed for by the petitioner. This court is not inclined to grant relief as prayed for by the petitioner in the state petition, which is hereby dismissed. Next.
One thing related, just at paragraph 15, it has been recorded in the LP order that the court's order has been complied and they have been reinstated. And
So
paragraph
30
16, LPS has been dismissed.
Paragraph number 15.
15, page 66.
You just put it, this order will require some correction, right? In paragraph 15 of the LP order,
Compliance has been recorded.
just a moment. Order dated 15 July 2022 passed in contempt case with matter civil number 1270 of 2019 and that matters have been mentioned, wherein the state of Jharkhand took a stand that by notification dated 13 July 2022, the order passed by the writ court has been complied by the state of Jharkhand.
In paragraph 16, LP 17, all the LPS have been.
That I have recorded, but all the LPS have been dismissed on delay, primarily. Isn't it? There will be some changes in the order. I have to correct it accordingly. Next.
Item 49, WPS 7009 of 2023.
No objection from your ex-employer?
It's just a show cause. Police after
You
challenge is just
respond.
a show cause.
You respond to the show
Yes,
cause.
but I understand the grounds for challenging a show cause is very limited. The only thing is because I have some valid grounds because I was a probationer.
I need not enter.
No, your lordship need not enter. Only your lordship will say that they will decide it freely.
You respond.
I
When
will
do you want to
respond,
respond?
because no ground for interference in a show
When
cause.
did you? When do you want to respond? Within a week?
2 weeks. 2 weeks have to, but they should decide it independently and fairly. That's all.
I'll
After
take
giving
care
the opportunity.
All the proceedings, whatever, you take care. You give him an opportunity of hearing.
Yes.
They are bound. You are bound to do.
Yes,
so.
that must be.
WPS number 7009 of 2023. Counsel for the parties are present. District petition has been filed for the following relief. At the threshold, counsel for the petitioner has submitted that the writ petition has been filed against a show cause, notice. He submits that the petitioner is willing to file the reply to the show cause notice within the period of 15 days from today.
Just one ground raised by the petitioner is not covered with the scope of interference, that is jurisdiction and malafide.
I will just.
Acha,
I will take care of everything.
Yes.
Don't worry. Everything will be kept open. Don't worry about it. You see, all the proceedings are recorded, so we have to be very, very careful about whatever we are dictating. The orders which we are dictating in open court, I'm just making it very, very clear to all of you. It's certainly subject to corrections, and I may add a few ground in addition while correcting it. But the nature of the order will certainly not.
This is just a structure.
It is just a structure.
Broad structure. That's fair.
This is a broad structure.
Yes.
So your submissions are also equally important. So
Yes.
take care of that. And it is going to be permanently there in YouTube now. So these are
It's
live.
from 215. I see it. It's from 215 bench.
Even 10:30 proceedings are. I think it is there recorded. Everything is there.
कल परसों तक 215 हम तो जाके शाम को
नहीं भाई देखा करें.
चल रहा है.
हाँ.
अच्छा है.
बहुत अच्छा है. I'm very happy about it. No counsel will speak out of record. This is what I want.
It's a reminder should be. We tend to
Under CCTV surveillance.
we tend to forget.
I don't need to. I want.
No. For us.
Be very, very careful in making submissions.
Yes, certainly.
And it's a way to ensure that there is no ruckus in the courtroom.
It is a very good thing for
Very
both.
good.
For us
For
also,
everybody. For me also.
Yes,
And for you
everybody.
also.
Everybody knows for clients, most importantly, what was argued. What was not
Any
argued.
day they can see, they can go to the YouTube and see that what their counsels are doing. So this is what I want. And I'll ensure that I'll keep my mind cool.
That's very important.
I'm a very cool person, don't worry about it. You respond to my query, you get an order. Last sentence, what was it?
The learned counsel submits that the petitioner is willing to file a show cause notice within a period of 15 days
From today. The learned counsel has also submitted that all the points be kept open and the respondents be directed to give an opportunity of hearing to the petitioner. And that would suffice so far as the present case is concerned. Right? Counsel for the respondents has no objection to the prayer made, considering their aforesaid submissions and the fact that the petitioner has approached this court against a show cause notice. This court is not inclined to grant the relief as prayed for by the petitioner in this writ petition. However, it is, as undertaken by the petitioner, he shall file his show cause reply within a period of 15 days from today. Upon filing of such reply, before whom will you file?
It will be still issued by the secretary government only. I will file before the additional secretary is given the.
The concerned authority would grant an opportunity of hearing.
Just follow the service rule, whatever the service rule is.
The concerned authority shall grant an opportunity of hearing to the petitioner and pass appropriate order without being prejudiced by the fact that this court has refused to interfere with has refused to grant relief as prayed for by the petitioner in the state petition.
And in
The
accordance-
petitioner shall also produce a copy of the records of this case along with his reply to the
Just one, in accordance with law, because.
in
service
accordance
will-
with law, certainly.
Over.
Add in accordance with law. Disposed of, right? Next.
Passover case item 30, WPS 1724 of 2023.
Since the previous orders of this Honorable Court, Your Lordship, more particularly the order dated.
Who is for the respondents? You are making ad hoc arrangements and you don't give promotions.
As for that, there has not been any final decision, Lordship.
Sorry?
There has not been any final decision, Lordship, for making the permanent post, Lordship.
So,
Main
for
benefit
taking
is
the
that
permanent post, from where do you say so?
the main advantage this department gets, Lordship, that we also take the work of teachers from them, Lordship. But as
No,
soon as
I just want to know. Come to your counter
Yes,
affidavit,
Lord.
please. Stick to your counter affidavit,
Yes,
isn't it?
More particularly.
Interstate seniority list has been prepared.
Seniority is prepared, Lordship.
So
But
at
that-
least one step has been done. Now you come to this, page number 22
Yes.
of your counter. As and when promotional exercise is completed, the posting to the post of principals and superintendent of state medical college would be done as per rules.
Yes, Lord.
So rules are also in place,
In place, Lordship.
right? Now you come to page number 34.
Lordship.
34.
Yes, Lord.
नोट, इन पदों पर प्रोन्नति कार्मिक प्रशासनिक सुधार तथा राजभाषा विभाग द्वारा गठित प्रोन्नति समिति एवं कार्मिक विभाग द्वारा समय समय पर प्रोन्नति हेतु गठित अन्य समिति द्वारा किया जाए. राइट? नाउ देयर इज अ सर्कुलर बाय राजभाषा डिपार्टमेंट that twice departmental promotion committee will sit in a year.
Yes, Lordship.
In the year 2014 only it was there. You are not aware?
Yes.
दिखाइए भाई इनको.
How-
दिखाइए.
They
They are
are
not aware
only-
of their own circular.
Thereafter only ad hoc appointment has been made, Lordship.
Therefore, I want to know
President.
why this ad hoc arrangement is continuing for an indefinite period of time. If you have a rule in place, you follow it. You yourself has come up with a circular that departmental promotion committee meeting will be held twice a year, but you don't follow it.
And also may make
You have
one
not
submission.
even given any time frame. How much time will you take to convene the departmental promotion committee
And
meeting?
Lordship, his presentation is still pending. This also-
Representation
Give
is
the
not
time
going
frame-
to solve the problem.
Give the time frame, Lordship, by that, Lordship.
You just tell us, you give your time frame, because your time frame you have already given in your circular. इनको दिखाइए जरा, ऑर्डर दिखाइए इनको, वो फाइल दिखाइए, show him the circular.
That is there, Lordship. That's a regular promotional committee establishment, Lordship.
नहीं नहीं, जो एक रिकॉर्ड मंगाए थे ना, जो ऑर्डर था फर्स्ट केस के लिए ऑर्डर जो था, नहीं नॉट दिस, जो पहला केस में आपका ऑर्डर नहीं था, ये सौरभ जो अपलोड किया था, सौरभ जो ऑर्डर अपलोड किया था, हम आप निकाल के प्रिंट दिए थे, ये वाला ऑर्डर.
ये वाला,
हाँ,
तीन ऑर्डर.
WPS नंबर 3 of 2023. इसका फाइल है, फाइल मंगाया इसका. Is it there?
ऑर्डर.
You see, it provides that राज्य के विभिन्न विभागों में प्रशासनिक नियंत्रणाधीन सभी सेवाओं संवर्गों में प्रोन्नति के रिक्त पदों के विरुद्ध अर्हता प्राप्त कर्मियों के प्रोन्नति की त्वरित कार्रवाई की जाएगी. इसके लिए वर्ष में कम से कम 2 बार विभागीय प्रोन्नति समिति की बैठक अवश्य आहूत की जाएगी.
This also, Lordship, has observed. According to the read petition disposed of, directing respondent to promptly conduct the meeting of Department Promotion Committee for the claim of promotion of all eligible candidates, including the petitioners, in case there is no other legal impediment.
That's within
Same
time
of
frame.
the-
Time frame must have also been given.
Yes.
Within a period of 3 months. Are we agreeable for this order?
Yes, sir.
And only one thing, if your lordship shows the concern, because it relates to medical college, not
That is why we are
Can
concerned.
you see the statement in paragraph 12? In paragraph 13, also they are making ad hoc appointments in professor also, so the contractual.
Everything I have observed in your favor only.
Yes,
So
ma'am.
that is why 3 months time, their promotion rules are
That is so far as
ready.
my client will be, his grievance will be redressed.
Everybody's grievance will be redressed because the departmental promotion committee will take care of all the
Yes,
persons, isn't it?
Because it is the only state where professors are appointed on contractual basis in medical colleges.
Let us see. Learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the grievance of the petitioner is that ad hoc arrangements are being made instead of granting regular promotion to the eligible candidates. And consequently, pick and choose method is being adopted, and the petitioner has been left out from consideration. A counter affidavit has been filed in the present case. The learned, should I record that you are referring to this circular, or you are referring to this order?
This order.
The learned counsel has also. Have you seen this order?
Yes, yes.
Has also referred to order dated. Order passed in WPS number 03 of 2023, dated 5/2/2024, wherein the circular of the state government regarding convening of meeting of departmental promotion committee twice a year has been taken into consideration, and appropriate direction has been passed with a time frame. The learned counsel has submitted that as per the counter affidavit, the seniority list has been prepared, the rules governing the promotion has been annexed, and it has been mentioned that the promotional exercise will be completed. Once the promotional exercise is complete, appropriate posting will be done. He submits that no schedule or even a tentative date has been mentioned in the counter affidavit as to when the meeting of departmental promotion committee will be convened. The learned counsel, appearing on behalf of the respondents, has submitted that this writ petition can be disposed of in terms of order passed in WPS number 3 of 2023. And not only the petitioner but all the eligible candidates are required to be considered. So isolated case of the petitioner, or isolated order in case of the petitioner may not be passed, right? After hearing the counsel for the parties and considering the aforesaid facts and circumstances as submitted by the learned counsel for the parties, this court finds that as per the counter affidavit, interstate seniority list has already been prepared and the rules for promotion is in place, and it has been mentioned in paragraph 19 as follows. Quote kar dijiyega, please. Page 21 of the counter affidavit. In the order dated 5/2/2024, passed in WPS number 3 of 2023, this court has taken note of the notification dated 4/4/2014 of the state government, which itself provides that the meeting of departmental promotion committee is to be convened at least twice a year. apparently in the present case and from the perusal of the records, the matter regarding promotion is pending for quite some time, and ad hoc arrangement is being made with respect to different institutions. This court is of the considered view not only the case of promotion of the petitioner is required to be taken into consideration if the petitioner is otherwise found eligible, but the case of other similarly situated persons is also required to be considered. Accordingly, this accordingly, this petition is disposed of, and this court finds that the respondents have acted against their own policy of convening 2 meetings of departmental promotion committee in every year. Accordingly, this then you have para 9 and 10 of this order, right? This writ petition is disposed of with the aforesaid observations.
Also, case item 37, WPS 4936 of 2023.
Yes, petitioner. Yes, where is the petitioner? And where is the other petitioner?
I responded to your lordship JFCC. How far statement?
एक और है ना पास follow this.
Item 39, WPS 5768 of 2023.
Mr. Thakur, petitioner is not there in the other connected case. Petitioner is absent in the other connected case and posting it tomorrow to give one opportunity. If they do not turn up, we will pass appropriate order in connection with both the cases. The learned counsel for the parties are present. Both these cases are required to be heard together. The advertisement in connection with the recruitment process has been placed in WPS number 4936 of 2023, which will be considered while deciding WPS number 5768 of 2023 also. Since the petitioner in WPS number 4936 of 23 is absent, in order to give one more opportunity to the petitioner, post these cases tomorrow. On 15th.
Yes.
Supplementary list, it will be there. Those petitioners are from different state. Maybe that they are not interested. Tag with Kati.
Item 50, WPS 7028 of 2023.
Petitioner retired under PRST on 31/9/1999.
What were you doing since 1999? Where were you?
At the time of working, petitioner was working in South Canary, and after that you merged in.
I just want to know that you took VRS in 1999. What were you doing? You have filed the state petition as 2023.
My lord.
And in your representation only you have stated that the respondents do not have the records. Then what benefits can be granted to you?
Our retirement benefit has not paid, my lord.
We do not know. You see, since 1999 you are sleeping. You have taken.
Colliery merged in a different career, so the document is not achieved. So I can. How can
Since
I
1999, you have slept over your rights.
तो illiteracy के कारण रिपोर्ट नहीं किया, यही बात.
You just tell us under what law illiteracy is a ground for not approaching this course since 1999?
हमारे यहाँ जो आएगा तो वही ना फाइल करें my lord. Petitioner working in the office of the CCL that it had paid
You have
and the
received-
merge in the colliery merge in other colliery and document is not so there is no payment made.
How will that payment be made to you? How will they verify the records?
Recording with Tapin South Colliery and Tapin South Colliery merge in Tapin North Colliery my lord. क्योंकि तापिन साउथ कलरी है बिकम अभी बंद हो गया तो उसे मर्ज कर दिया उसमें एक बात घर में दो कलरी है अगर एक तापिन साउथ कलरी एक तापिन नॉर्थ कलरी तापिन साउथ कलरी में कर रहा था बरकर ये अभी बंद हो गया तो इसको
You have taken VRS,
my lord.
right? And you have taken all the benefits under the VRS.
There is only payment has made as the provision of the rest सर्विस पीरियड का पर ईयर 1.5 महीने का वेतन मिलता है ये
No, you have stated in your counter affidavit that the petitioner has not been provided with the retirement dues except the voluntary retirement scheme amount. So voluntary retirement scheme, where is that scheme?
स्कीम में था कि 1.5 महीने का वेतन पर ईयर मिलता है वही में
So that is why you say that you have received the amount under the voluntary retirement scheme amount. You have received it. Are you entitled?
अमाउंट जो प्रोविजन था बीआरएस स्कीम में कि बचा हुआ पीरियड का पर ईयर 1.5 महीना या जो पीरियड बचा उसका जो वेतन होगा जो कम होगा मिलेगा
कहाँ है? Where is that? अभी आपको हिंदी में समझा, ठीक है? आप पेज नंबर 6 में आइए. And you say that the petitioner has not, page number 6, para number 6, last 3 lines, the petitioner has not provided the retirement dues except the voluntary retirement scheme amount. According to the petition, you have received the amount under the voluntary retirement scheme. Still you are entitled for pension.
पीरियड जो था वो पेमेंट हमको खाली वेतन पीरियड हुआ पेमेंट हुआ जो रिटायरमेंट बेनिफिट का जो है हमारा जो उसके बाद जो ग्रेचुटी होता है हमको नहीं मिला हमको जो सीएमपीएफ नहीं मिला पेंशन नहीं मिला मतलब ये नहीं मिला यही तो कुछ ही वॉलंटरी कार्ड में जो वेतन मिलता है वो हमको मिला प्रोविजन है वेयर स्कीम में लॉर्ड
Where is that scheme?
स्कीम तो हमारे पास नहीं है मेरा तो हमको रिटायर किया लेटर में लिखा हुआ और ये तो मेरे लिए तो सीसीएल ना बताएगा स्कीम का कॉपी हम कहाँ से देंगे तो सीसीएल ना देगा बिहार स्कीम क्या है
आपने खुद ही अपने लेटर में लिखा है कि लेकिन रिकॉर्ड न मिलने के नाम पर अभी तक सीएमपीएफ ग्रेचुटी साल छुट्टी की रकम और रिटायरमेंट के समय पेंशन भुगतान नहीं किया जाता
तो रिकॉर्ड जो है हम वही तो बोल रहे हैं मतलब कि तापिन साउथ कॉलेज में हम काम कर रहे थे तब रिटायर किए और वो कॉलेज बंद हो गया तो मर्ज कर दिया गया 2002 में उसको मर्ज कर दिया गया तापिन साउथ कॉलेज और वर्कर ट्रांसफर वहाँ कर दिया तमाम जगह तो वो कॉलेज बंद हो तो रिकॉर्ड तो उसके
I'll tell you one thing. I can call for a counter affidavit. But if the records are not available, then we will not grant you any relief, even if it is post-retirement.
रिकॉर्ड तो होगा ही क्योंकि तापिन
We do not know. Let them say whether the records are available or not.
काउंटर में देंगे लेकिन रिकॉर्ड है हम जो कर रहे हैं ना हमको तो
You find it out if he is entitled, if the records are available, figure out what all has been paid to
If all
him.
the ifs are satisfied below, certainly he should be getting it. But the scheme at least should have been attached. We also do not know what is remaining.
कहाँ से स्कीम तो सीसीएल का ना है सीसीएल ना देगी
आपका क्लाइंट अनपढ़ है आप तो अनपढ़ नहीं है ना I am asking them to file a counter affidavit. Still you are shouting. Why are you so anxious? 99 you have taken VRS. You are coming in 2023. Don't you see your latches? The learned counsel for the parties are present. The learned counsel for the petitioner submits that the petitioner was granted voluntary retirement as back as on 30/8/1999 as contained in Annexure 1 but except the voluntary retirement scheme amount, no other benefit has been paid to the petitioner. While answering the question as to why the petitioner did not approach this court earlier, the counsel for the petitioner has submitted that the petitioner has been representing before the authorities, but no decision was taken. However, from the representation dated 5/10/2023, it is apparent that the petitioner has himself mentioned in the representation that the connected records are not available. The learned counsel has submitted that, has referred to paragraph 6 of the writ petition to submit that the petitioner was working in Tapin South Colliery, and after that Tapin South Colliery has merged in Tapin North Open Cast Project. But the area office as Hazaribagh area of Central Coalfields Limited was the same. He submits that if the respondents would look for the records, the same could be made available, and the legitimate dues of the petitioner, particularly relating to his service benefits, be provided. The learned counsel for the respondents has submitted that the case suffers from enormous delay and latches. Mere filing of representation is not sufficient. She has also submitted that the question of giving any benefit to the petitioner would arise only if the records are available. She has also assured this court that appropriate efforts will be taken to trace out the records and file before filing a counter affidavit. The scheme of voluntary retirement, before filing a counter affidavit in the case, the counsel for the respondents is directed to seek instructions and file a counter affidavit by 18th March. 18th March 2024. Post this case on 19th of March under the heading for admission.
Item 51, WPS 7031 of 2023.
Yes, petitioner.
It's a similar matter of WPS number 903 already filed our counter affidavit, and there we have stated all the case numbers which have been decided by this court. Yes.
What is the order she is pointing out? By which court it has been?
Similar matter.
This court
By this
only.
case.
देखिए जरा. The learned counsel for the parties are present. At the outset, the learned counsel for the respondents has submitted that a counter affidavit has been filed in the present case, and the case of the petitioner is squarely covered by a judgment dated 11/4/2023 passed in WPS number 418 of 2023. The learned counsel for the petitioner has in turn referred to order dated 5/2/2024 passed in WPS number 2903 of 2023, wherein the aforesaid order relied upon by the respondents has been followed. She submits that similar order may be passed in the present case also. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that this case is squarely covered by the judgment passed in WPS number 418 of 2023. The 814 and 418 are two different orders. 814 दिखाइए तो 814 of 2023. 814 of 2023. A similar order has been.
11 of the notice for you.
The learned counsel for the respondents has also relied upon order dated 11/4/2023 passed in WPS number 418 of 2023, which is on similar lines. The said order has been annexed along with the counter affidavit. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the petitioners are seeking mandamus from this court upon the respondent to accommodate and absorb the services of the petitioners who are working on contractual basis.
Yes.
In the
More than 2 years.
respondent, which college is this?
SRT College, Dham, Godda. University, SAM University.
In SRT College, Dhamri. Godda. And honorarium is being paid to them. The petitioners are also seeking a direction upon the respondents to immediately frame a scheme of absorption and accommodation of the services of the petitioner, and they are under apprehension that they are facing danger of going out of service by virtue of implementation. Baki paragraph number 22, 23, 24. This court finds that the present case is squarely covered by the aforesaid judgments passed by this court and is accordingly disposed of in the same terms.
Item 52, WPS 7044 of 2023.
Investigate while Annexure 3, members of petitioner sons were granted 15% allowance in terms of 7th pay commission. But while Annexure 7, which is at page 52, without any so cause, this said allowance which was granted by the Annexure 3 has been directed to be recovered now. Without any so cause to either to the petitioner son or to the members of the son. Annexure 7 is at page 52. In the first paragraph, it has been mentioned that in terms of which decision the allowances were paid, and in the second paragraph, it has been mentioned that सभी कार्यालय प्रधान स्वास्थ्य विभाग जिला लातेहार निर्देशित है कि अपने अपने अधीनस्थ कार्यालय
Are you sure that the name of the persons whom you have mentioned in the list in the supplementary affidavit, they have not filed their individual petitions?
Their individual petition.
Are you sure?
It is on behalf of they are the members of the son, and the son.
See, the practice which has developed in Jharkhand High Court is that one Sangh files a case, then individual petitioners also file a case.
My Lord, I have taken an instruction to that effect that only Sangh is representing.
I am recording your.
the district.
I am recording your submission, and you will be responsible if any independent cases pending before this
From the
court.
district Latehar, madam. This is from.
I will, this name is already there.
Madam. Because it has been filed on the basis of.
You file your counter affidavit. The learned counsel for the parties are present. Counsel for the petitioner has submitted that a list of members of the petitioner association from the district of Latehar has been mentioned in the supplementary affidavit dated 2/1/2024, and none of those have filed any independent writ petition before this court
As per the.
in connection with the issue involved in the present case. Counsel for the respondents is directed to seek instructions and file a counter affidavit. The list of persons whose name has been mentioned in the supplementary affidavit is as under. इसको पूरा लिस्ट को ना एम्बॉस कर दीजिएगा. आप देख लीजिएगा इसमें से कोई का इंडिपेंडेंट फाइल हुआ है कि नहीं. Then we will see what is to be done. How much time do you need to file a counter?
Your Lordship, 4 weeks.
Time till the counter affidavit be filed by 12th of March. You can seek instructions on supplementary affidavit also.
Yes, Your
At this
Lordship,
time, we need not emboss it.
Lordship, I will seek instruction
Okay.
on
The
whether
counsel
names
for
is-
the respondents shall also seek instructions with respect to the persons whose name has been mentioned in the supplementary affidavit as to whether they have filed any independent writ petition with regard to the same cause of action.
I am aware of petition filed by Sangh West
I do not
Ranchi.
know. Whatever you have done, what you have
But from
said.
the district
I-
Latehar, they have not filed individually.
Let us-
Of the date.
Date is, we have given 12th March post on 19th. Under the heading for admission.
Item 53, WPS 7085 of 2023.
WPS number 7085 of 2023. Counsel for the parties are present. Counsel for the state is for and is granted. Time till 20th February. 20th February 2024 to seek instructions and file a counter affidavit in the present case. Rejoinder if any by 23rd February, post on 27th February in the under the heading for admission.
Item 54, WPS 7133 of 2023.
बोलना नहीं पड़ा कि अच्छा लगा.
काउंटर की जरूरत है तो बोलना क्या है?
जरूरत तो होती है.
कोर्ट भी कभी कभी फाइल पढ़ के आते हैं, ऐसा थोड़ी.
नहीं कभी कभी नहीं. आपके यहाँ तो I have seen you last so many years.
काम है हम लोग का पढ़ने का. पिटिशनर नहीं भी रहे तो भी उसको ऑर्डर मिलना ही चाहिए.
Presented petition notice has been filed, Your Lordship, for implementation of Annexure 10 and 13, Your Lordship. Annexure 10 and 13 pertains to, Your Lordship, that
WPS number 7133 of 2023. Counsel for the petitioner is present. Issue notice to the respondent number 6 and 7, for which requisites be filed under speed post as well as ordinary process by Friday, by 16th of February 2024. The learned counsel for the respondent number 1, 2, 5 are directed to seek instructions and file a counter affidavit in the present case. Let the counter affidavit be filed by 12th of March 2024 Posed this case on 19th of March 2024 under the heading for admission.
Item 55, WPS 7164
It
of
will be
2023.
open to the petitioner to file a rejoinder to the contract prior to the next stage of the
The state had filed counter affidavit. I'm praying for 2 weeks time for filing rejoinder.
You file a counter affidavit seeking instruction from respondent number 4.
Respondent number 4. Yes, sir.
The secretary should file an affidavit, and your counter affidavit should specifically deal with annexure 3.
Yes, sir.
Because as per the chart, the various persons who had applied in different districts have been given the benefit, and as per the advertisement, they could not have applied in multiple districts. So their candidature is under cloud.
Specific supplementary counter.
It is relating to Manrega, we will take it very seriously. So specific counter affidavit should come from respondent number 4. Right? Counsel for the parties are present. District petition has been filed for the following relief. It is the case of the petitioner that in terms of paragraph 4H of the advertisement, candidates for the post could apply in only one district, and non-compliance of this would automatically cancel their application. It is the grievance of the petitioner that instead of this, many candidates have applied for more than one district and got their name in the final merit list. A counter affidavit has been filed in the present case on behalf of respondent number, Director
DRDA.
on behalf of respondent number 3, and the statement made in paragraph 9 of the counter affidavit has not been denied. Counsel for the considering the nature of issue involved in the present case, counsel for the respondents is directed to seek instructions and file a counter affidavit on behalf of respondent number 4, who in turn would get the facts mentioned in annexure 3 to the writ petition in form of a chart duly verified by taking the information from the concerned districts and file a counter affidavit. Let the counter affidavit be filed by 12th of March 2024. The rejoinder, and post this case on 13th of March. If the fact is found correct, notice is to be issued to all the persons, because they have ultimately they have been appointed. Appointed.
They are
Are you
working.
sure? They are working.
That has come up in the counter. They are working.
We will see if the if you just point out on the next day. If required, we will make them party, and then notice will be issued through the department, because they are working under the department. Okay. I have given a date.
Item 56, WPS 7220 of 2023.
Yes, petitioner.
Question for annexure 5 at page 37 by which
Page number?
at page 37, my lord, by which they have denied that I am not entitled for second and third MSCP as because the adverse entry has been made in my survey.
So, are you still entitled?
Yes, my lord.
Are you still entitled?
Yes, my lord. As because the adverse entries has been made not in accordance with the law and it is against the rule 292 and 299 of the Bihar Service Code.
292 and
299 para 16 में हमने quote कर दिया.
para number?
Para 16 at page 2.
Just a moment. No counter has been filed.
No counter has been filed.
We'll take care of it.
Counter is required.
Adverse entry has been made on what ground? What is the adverse entry?
That ground has not been assigned, my lord, and it has been entered without any permission of the head of the department, my lord. 292 says that the personal certificates of character must not, unless the head of the department so directs, be entered in a service.
It is a sequel to some order passed in the writ petition.
Yes, my lord. Earlier I have.
You were party in that proceedings.
I prefer the writ application for the grant of ACPA, my lord, and MSCPA, which is at that has been disposed of at annexed.
You were the same petitioner, Arjun Prasad Sahu.
Yes, my lord. Page 34. At page 34, this report has directed the respondent. At page 35, my lord.
The learned counsel for the parties are present. Counsel for the petitioner has submitted that by the impugned order as contained in Annexure 5, the claim for ACP and MACP has been denied to the petitioner by referring to adverse entries made in service book. The learned counsel has referred to para 16 of the petition to submit that the alleged adverse entry has been made in total violation of Rule 292 and 299 of Jharkhand Service Code, and therefore such entry cannot be a basis to deny the relief to the petitioner. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case by 27th of February 2024. Rejoinder, if any, by 5th of March. Pose this case on 12th of March under the heading for admission. Next.
Item 57, WPS 7250 of 2023.
Yes, petitioner.
The order under challenge is Annexure 7, page 40.
What is the nature of order?
This is the order whereby the respondents the DSC has directed the secretaries of the school to cancel the appointment and to issue the fresh advertisement.
Appointment was done after due process.
Yes.
You are the minority. You are working in minority school. Where is the advertisement?
Advertisement, my lords, is page 2, my lords. Sorry, Annexure 2, my lords, is page 34. This is the, my lords, the requirement. Annexure 2, my lords, is
Where
page
is the
34.
where is the representative of the state on the board?
Annexure 3, my lords. Annexure 3.
Okay.
Page 36. This BO has been appointed as a representative on behalf of the government, my lords, to see that
What is the reason for cancellation?
The reason for the cancellation with the assigned, my lords, that my father is the secretary of the said minority schools. So the entire process was carried out under his supervision.
and I am the daughter of the secretary, my lords.
When the departmental representative is there on board, then under such circumstances, how such an allegation can be made? Merely because daughter of secretary is participating. Was he a member of the board?
No.
He was not a
No.
member of the board. Please file your complaint.
Yes, it's the reason which has been assigned us. They have written that जांच प्रतिवेदन के अवलोकन से स्पष्ट होता है कि आपने अपनी उपस्थिति में ही नियुक्ति की संपूर्ण प्रक्रिया को संपन्न कराया है एवं नियुक्ति प्रक्रिया में सम्मिलित रहते हुए अपनी पुत्री की नियुक्ति आपके द्वारा की गई है जैसा कि
So this has to be, you see, this is something post the process, right? So you have to bring on record some material.
Yes, yes. If he is not part of the process, then there is no reason why the daughter should be not be given. Yes, yes, that's true.
The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the matter relates to appointment in minority school. The impugned order has been passed by alleging that the petitioner, being the daughter of the secretary of the school, has taken appointment by undue influence. Yeah?
Other secretary actually under
Yes.
his supervision appointment.
And the appointment was done under his supervision. The learned counsel has submitted that the required procedure for appointment in minority school has been followed. A representative of the state was also present in the interview board, and advertisement was also issued. He has also submitted that the secretary of the school was not a member of the board which had taken the interview. The learned counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case, bringing on record the inquiry report on the basis of which the impugned order has been passed. Issue notice to the respondent number
8 and 9. They are the secretary and the principal of the school.
8 and 9 under speed post as well as ordinary process, for which the requisites be filed by Friday. Post this case on March 2024 under the heading for admission. The counter be filed by 27th February, the rejoinder by 6th of March.
If you're 19 plus, some personal difficulty.
All right? No, okay. By 19th, you want to file?
It's 12, and it will be 19th March.
All right, on 19th March.
One prayer, Mullahs. I would request Mullahs to stay the lecture 7 because of the fact, Mullahs, they are proceeding to initiate a fresh advertisement.
Don't worry about it. Everything will be taken care of. By this time, you see, don't crystallize don't create third-party rights. And unless the minority school issues advertisement, the state will not, can't force you to issue
Direction has already been issued, Mullahs. Direction has already been issued, Mullahs, in the
We'll take
orders.
care, we'll take care. Yes, you inform them unnecessarily, and by this time the case will be decided on the next day. If this board is there, it will be decided.
Yes.
Right? You need to just mention, because in the second half, many matters are there. If you mention it, we will take care.
It's counted by which date?
27th February. Is that okay?
It's one more week.
Okay. 5th March.
5th.
Because in this case, there has been allegation, counter allegation, all these things were there.
We'll take care. The notice to the private respondent should accompany a copy of this order. The private respondent, while filing their counter affidavit, shall annex a copy of the records in connection with a copy of the entire records in connection with the recruitment process involved in the present case. Appointment process.
Item 58. WPS 7260 of 2023.
Yes, petitioner.
This is the entire departmental proceeding, including the charge sheet and transaction 4 is under
Charge
challenge.
sheet you are challenging.
Yes, madam. Because the Marat premises the charge sheet, it has been issued on the basis that I wrote a complaint to the senior officers of CCL through an email. That is the charge. And Marat, to the facts of the case, what has happened, Marat, the petitioner was appointed under the land loser scheme, madam. She completed the probation period and
See,
there.
we will not interfere with that.
My leadership, one thing is there that the departmental proceeding is pending since 2.5 years, more than 2.5 years, madam.
That we will take care.
Yes, that and CCL standing order says that it should be completed within 60 days. And there
That
is
we
no,
will do. Who is for CCN?
I am okay.
Why don't you complete?
I will do that any time set by this court. I will abide.
You have filed your show cause?
no, so cause.
No.
Yes, replies have been filed and I have not been asked to appear in any of the signal dates, madam. They are time and
Not
then-
even one date has been fixed?
No, nothing.
Are you still in employment?
Yes, ma'am. I am still in employment. And 2 inquiry officers have been changed. Apart from that, nothing has been done.
We will abide by the order of the court. Whatever time is framed, we
And
will do that.
in garb of this departmental proceeding, madam, my promotion and other benefits are also.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the entire departmental proceeding has been initiated with a malicious intention. He submits that the matter is pending since 2021 and the petitioner has done the needful at his end, but the respondents have not yet passed any final order in the matter of departmental proceeding and not even a date has been fixed by the respondents. He submits that the pendency of the departmental proceeding has become a reason to deny all the promotional avenues to the petitioner. The learned counsel appearing on behalf of the respondents has submitted that the charge memo may not be quashed by this court and appropriate order can be passed to take the departmental proceeding to a logical end. He submits that some time frame may be fixed and needful will be done.
Yes.
The petitioner be also directed to cooperate with the proceedings. After hearing the learned counsel for the parties and considering the nature of relief as sought for in this writ petition, this court is not inclined to quash the charge memo issued to the petitioner dated 3/6/2021. However, at the same time, the departmental proceeding cannot remain pending for an indefinite period. And considering the submissions made by the learned counsel for the respondents, this writ petition is disposed of with a direction upon the respondent number 3.
Project officer 4.
With the direction upon the respondent number 4 to take all steps so that the matter in connection with the departmental proceeding is taken to a logical end and final order is passed within a period of 4 months from the date of receipt of a copy of this order. The petitioner is directed to appear before the respondent number 4 along with the writ records and a copy of this order on 22nd February 2024.
Only ample opportunity may be provided to them.
Sorry?
Ample opportunity may be provided to them.
Everything will be done. You don't worry about it.
Okay.
This writ petition is according to this petition. उसमें ना in accordance with law within 3 months in accordance with law.
Item
3
59.
months or 4 months, madam?
4 months.
4 months, madam.
4 months.
Yes.
Item 59
You
WPS
see,
7
these orders are all subject to correction because at the time
I
of
heard it 4 months,
dictation,
that's why I wanted to submit my order.
at the time of dictation, there could be some error, but
Yes.
the nature of the order will certainly not
My
change.
lord, we will do that.
Yes, please. Petitioner?
Yes.
Para teacher.
Para teacher
participated in counseling and declared successful by Annexure 3. However, till date, the appointment letter has not been issued and no final decision has been taken whether his candidature has been, appointment has been validated.
Annexure 3.
Annexure 3, Your Lordship. And the name appears at
Page
page
number?
number 23, Your Lordship, at serial number 8.
When was this result published?
This was published after the counseling of, it was published on 13/6/2019, page 24. 13/6.
You were under which category did you participate?
Under BC category, Your Lordship.
No,
Which
no. Para teacher, non-para teacher.
Para teacher, Your Lordship.
Para teacher applied under?
Para category. Page 22 may be seen for that. इंटर प्रशिक्षित शिक्षक पारा शिक्षक पद पर चयन हेतु नवम काउंसलिंग में सम्मिलित होने के उपरांत अंतिम चयनित अभ्यर्थी की औपबंधिक मेघा सूची.
Learned counsel for the parties are present. Counsel for the respondents is directed to seek instructions and file a counter affidavit in this case by 20th of February 2024. Rejoinder, if any, by 23rd, post on 27th February under the heading for final disposal. At 2:15. You do the needful. Para teacher का कहानी नहीं खत्म होता. You have to disclose the reason as to why the appointment letter has not been issued.
I will seek instructions.
And you can make the case infructuous also. Next.
Item 60, WPS 7293 of 2023.
Yes, petitioner.
Ladyship, in this I have been dismissed by retrospective effect by the memo contained in Annexure 4. What has happened, brief history, Ladyship, that I was posted in Block Development Office. I was convicted in a criminal case. When I was granted bail, I again joined it. On eve of my retirement, when even the pensions was formalized and sent to the district treasury by the assistant AG, the DC has been pleased to dismiss me without issuing me any show cause, without even asking a reason for my dismissal.
You have been convicted?
I have been convicted, I am under bail. The sentence has been suspended by this honorable court. In that
The
order
conviction has been suspended? The conviction has been stayed?
Stayed.
Conviction has been stayed or sentence has been
Sentence has been suspended.
So
That
you
is in
still
Annexure-
remain
Annexure
convicted?
three. I have been convicted. I have been convicted.
So what right do you have to continue? What is the date of conviction?
The date of conviction is at I've been convicted in criminal appeal. Criminal is on 23rd of February 2023.
What is your date of retirement?
I was supposed to retire on 31st of March 2023.
So what is the error in the order? Merely because show cause has not been issued, it should be set aside. No.
It should have.
No.
They should have issued.
A person who has been convicted has no right to continue.
I have been. I was allowed to continue after my after the.
Wrongly allowed.
Ladies,
No.
Under the rules, even the rule says that they should.
Once you are in
should-
custody for 24 hours, I think 48 hours, whatever the period is.
Ladyship,
While in service, you have been convicted.
While in service, I have been convicted. The sentence has been suspended by this honorable court. I was allowed to join. I was allowed to continue, and only on the date of my retirement, by the order making it retrospectively, they have made me to retire. Ladyship, see, may see annexure.
It's a retrospective date of dismissal.
Ladyship, may see annexure 4. They have written it on the concluding paragraph. उक्त पारित निदेशालय के आलोक में श्री विजय कुमार माझी लिपिक पांकी प्रखंड संयुक्त केंद्रीय कारा मेदिनीनगर के काराधीन
It is hardly 10-15 days आगे पीछे.
However, I should have been given a notice on the ladyship may see annexure 1. My pension and gratuity.
Natural justice is not like an unruly horse, right? What I am giving you natural justice. You say, what is your claim? You have been convicted, Mr. Das.
I have been convicted
While
under
in service.
304B.
Whatever be.
It is not related to my service.
Maybe it is not related to your service. Is there any law that if you are convicted otherwise than in service, you
Yes.
will not be dismissed?
There is a judgment, Your Lordship, which says that I will be entitled for PF. Gratuity. PF I will otherwise also be entitled. Gratuity
Otherwise also you
cannot
will be
forfeited.
entitled to gratuity.
This dismissal will take away my right of gratuity.
No, no.
Yes, Lordship, observe that much. Or I will satisfy you, Lordship. Today I could not bring
You
the
are
judgment.
concerned only with gratuity?
2 days only my retirement dues were to be paid.
That's right.
And
But
that
you were
in my
convicted
pension
while in
was-
service.
While in service. And also, even in cases of conviction, there has to be a formal show cause
No,
notice.
no, that is just a formality. In
Well,
226
that
I am not
formality
going to
also,
do this.
it is not just.
Need not be. You are convicted. No, it is not in dispute.
Yes, I have been
There was
convicted.
no scope. You would have attained the age of superannuation. So, this fact is not in dispute that you were convicted.
I was convicted
So what
for
natural justice are you talking
for
about?
an offence unconnected with the.
That's right.
Therefore, Lordship, I will be entitled for my
So
gratuity.
show me some judgment before I asked him to file a counter. Show me some
Lordship,
judgment
can it
that
be-
if you are convicted in a
Still, I will
case,
be entitled for gratuity if it is unconnected. So there is a direct judgment in Lordship where the conviction was under 498A. Lordship, keep it tomorrow. I will bring it.
right? If he is entitled to gratuity, you consider, but rest he is not concerned.
No, rest Lordship may only occur if I succeed in appeal naturally.
That naturally follows. For that, I don't need to observe anything.
Because I was going through the judgment also. He was a Chacha Sasur, made an accused under 304B without any. There is absolutely no material against him. It was misfortune that.
Gratuity, I think, otherwise also they give you. Don't
No,
they?
no, Lordship. Once it is a termination, unless there is an order, it will not be entitled.
WPS number 7293 of 2023. The counsel for the petitioner submits that the petitioner was scheduled to retire on 31/3/2023 and on 23/2/2023 the petitioner has been convicted for offence under section 304B/34 of Indian Penal Code. The petitioner has filed appeal against the order of conviction and the sentence has been suspended. But there is no order of stay of conviction. The learned counsel has submitted that no show cause was issued to the petitioner prior to issuing the order of termination or order of dismissal on just 2 days prior to his retirement. And he has also submitted that the petitioner would be that since the allegation against the petitioner is totally unrelated to the performance of his official duty, therefore the petitioner is at least entitled for gratuity. The same cannot be denied to the petitioner. Considering the fact that admittedly the petitioner has been convicted, this court is not inclined to accept the argument of the petitioner with regard to issuance of show cause. However, the petitioner has submitted that, has prayed that the matter be posted tomorrow so that he can place a judgment so far as the point of gratuity is concerned. The counsel for the petitioner has also submitted that these submissions are all subject to the result of the appeal and the right of the petitioner be kept intact if the petitioner ultimately succeeds in the appeal which is pending before this court. Post tomorrow?
Yes.
आप भी देखिए on it will come on next Tuesday. Post on next Tuesday under the same heading. ये अभी फ्रेश फाइलिंग कितना बचा है? 60 तक हुआ है, बाकी कितना है? 8 बाकी है, कॉल कर लीजिए. After this fresh, I will finish this fresh filing, then I will take up the defective matters. Just 8 matters are there. Call कर लीजिए.
Item 61, WPS 7319 of 2023.
Mayor, initiate the petition based on copy of order dated 26/2023 with annexure 20 binding the petition has been dismissed.
You filed it, Counselor. Learned counsel for the parties are present. Time till 27 February.
Even otherwise, it is an appealable order.
Is it an appealable order?
Appeal, we have also preferred the appeal.
Appeal is also
Appeal is
dismissed.
still pending.
Then you go and you can't have it both ways. You go and pursue your appeal. This I will not permit.
Lordship may dispose it of as a council and directing the appellate authority.
We will direct the appellate.
Yes, yes, that's why Lord, I am restricting my paragraph number 13, Lord. You and also include the copy of the appeal below, memo of appeal.
Appeal will be disposed of.
That may be of them, Lord. The appellate
The-
authority may be directed to dispose of my appeal below.
Para number?
Paragraph number 30.
Annexure 21 is there.
Annexure 21 is also included the memo of appeal.
Para number 30.
Yes, Lord.
Okay. The learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the respondents has submitted that the petitioner is availing two remedies simultaneously. He has filed an appeal, and during the pendency of this appeal, the present writ petition has been filed. At this, counsel for the petition has submitted that the appeal was filed as back as on 24th of July 2023, but no final order has been passed, and therefore the present writ petition has been filed. He submits that the appropriate order be passed so that the appeal be expeditiously decided. After hearing the learned counsel for the parties and considering the aforesaid submission, this court is not inclined to grant the relief as prayed for by the petitioner in this writ petition on account of the fact that the petitioner has already preferred appeal, and therefore the present writ petition against the order of punishment is not maintainable. However, since the appeal has been filed as back as on 24th of July 2023 before the CMD,
Coal India.
before the respondent number 1, the respondent number 1 is directed to take appropriate steps so that the appeal be decided within a period of 3 months from the date of communication of this order.
It's not already disposed of.
If not already disposed of. If the appeal has already been disposed of, a copy of the same be simply forwarded to the petitioner through speed post. The petitioner is directed to produce a copy of this order along with the writ records before the respondent number
1 year.
Respondent number 1 within a period of 1 week from today, 2 weeks from today. You want that should be sufficient.
Yes.
Disposed of.
Item 62, WPS 7320 of 2023.
Yes, petitioner.
This petitioner seeks direction from his promotion to the cadre of class 2 engineer, that is assistant engineer minus. The fact was the junior has been granted promotion and he has already been conferred the benefit of ACP and MSCP by annexure 6.
Junior is not a party. His promotion will be affected.
No, juniors have been already granted promotion. My claim is, Millers, that I was not conferred with the MSCP also.
Counsel for the parties are present. Counsel for the respondents is directed to seek instruction and file a counter affidavit by 27th of February, rejoindered if any by 5th of March. Post this case.
Somewhat 27th February, madam.
Kafi nahi? This was filed on 15/12/2023. That should be sufficient.
Because
Rejoinder by 5th of March 2024. Post this case on 12th of March 2024 under the heading violation.
because perhaps criminal proceeding is also pending against him. That
Very good. Bring it on
Once
record.
MSCP has been granted, same adjustic has to be adopted. Pursuant to order of this court, 21 years back when FIR
Item
pending.
63, WPS 7329 of
21 साल हो
2023.
गया।
What is the case, petitioner? What is the prayer?
Prayer is not for fixation of his pay in this scale of 4,000, 6,000 He is getting 3,200 to 4,000. Similar matter, Lord, was taken on before this one report, Lord. And Annexure 7 is there, page 45. There, my Lord, other page also, Lord, on the case of disposal representation, Lord. And that was considered by, ordered by the Annexure 7, page 45. And that order is passed.
Similar order can be passed?
And, to seek such whether the case is similar or not of the petition or not.
You have not seen the papers?
I've seen the papers.
Then?
They have to consider first on. There is observation of the court also. At first instance, they have to.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the respondents has submitted that no adverse order as such has been passed by the respondents with regard to the claim of the petitioners. Petitioner or petitioners?
Petitioner only, Lord.
You have filed representation?
Yes, ma'am.
He has submitted that a representation has been filed
Annexure 6,
by the petitioner as contained in Annexure
6
to this writ petition. As back as on?
Yes.
23/3/2023.
23/3/2023. But no decision having been taken, the present the writ petition has been filed. He submits that similar matter has been he submits that appropriate direction be issued for consideration of his representation. Who will consider it?
Respondent.
Respondent number?
Yes.
Respondent number?
4. Respondent number 3. Respondent number 3.
Where is the representation?
Yes. Respondent number 3, director may respond.
Where is the representation?
Yeah, Annexure 6.
The representation
Page
is
number,
43.
please.
Page number 43, Mala. But when a DC is got the party, Mala. He has been represented to the DC.
That's right.
Page number 43.
Deputy Commissioner come, settlement officer is also there. Settlement officer is party. DC used to be settlement officer. This one number 4 is there. Settlement officer.
The representation has been filed before the Deputy Commissioner cum Settlement Officer as contained in Annexure 6.
Yes.
After hearing the learned counsel for the parties and considering the nature of relief as prayed for by the petitioner, and the fact that no adverse order as such has been placed on record by the petitioner, and that the petitioner has represented before the Deputy Commissioner cum Settlement Officer Rachi for the redressal of his grievance as back as on 23/3/2023. This writ petition is disposed of and enabling the petitioner to approach the respondent number 4 by filing a representation with supporting documents along with a copy of the writ records within a period of 15 days from today. Upon filing of such representation, the respondent number 4 shall pass a reasoned order after granting an opportunity of hearing to the petitioner and communicate the reason within a period of 2 months from the date of receipt of the copy. The reasoned order be communicated to the petitioner through speed post. If the petitioner is found entitled for any monetary benefit, appropriate steps be taken so that the monetary benefit arising out of the reasoned order be also remitted to the petitioner within a period of 6 months from the date of the reasoned order. No counter affidavit has been filed in the present case, and it is observed that the state respondent will be free to take a decision in accordance with law, considering the applicable guidelines, circular, etc. This court has not entered into the merits or otherwise of the claim of the petitioner.
Item 64 WPS 7330 to 203.
It is similar matter also. Only
Same.
difference is that there is 5%. And whether this is pending before respondent.
Respondent number
3.
3. Who is respondent number 3?
Director may report.
Who is the authority who has?
Authority is the respondent 3 lordship because
In the said case also it is respond number 3
respondent
only.
3 only. Actually, he is the authority because if fixes a matter that has to be done by the actor.
लिखा ही जरा वो order. We will change that order. We will ask the respondent number 3 to take a call. He says that respondent number 3 is the appropriate authority. How will DC pass the order? That's right. He will pass a file a fresh representation. इसमें लिखिएगा, ठीक है? Counsel for the petitioner submits that although the representation has been filed before respondent number 4, but the appropriate authority to take a call with regard to the claim of the petitioner is respondent number 3. So you file your representation before respondent number 3 within 15 days from today. Who shall take part? The rest is the timeline. I'll give a timeline. You want any hearing also?
Yes, of course.
After granting an opportunity of hearing, this is the same. This one also?
Yes, respondent number 3.
In WPS number 7330 of 2023. The representation is pending before respondent number 3. And rest is same?
Yes.
You draft this order and bring it to me. Next.
Item 65, WPS 7333 of 2023.
Yes, petition.
So let's see, Mr. Anup Kumar, advocate from Supreme Court, was engaged to argue this case, but he could not join. He is still arguing this before the Supreme Court.
What is the matter?
You have challenged the advertisement, one clause of the advertisement, Your Lordship. Annexure 1, page 83.
The selection process, what is the stage?
Time to fill up the form has
Expired.
expired.
So what relief can be given, can be granted to you?
No, in one of the cases they have accepted that the candidates were allowed to fill up the form in both the cases, but there was ambiguity in this clause, let's say.
What were you doing?
No, we were trying to fill up the form, but the software was not accepting our form, let's say.
On what ground? Why was it not accepting?
Due to the registration being done from the same mobile number.
Same mobile number?
Same mobile number and
Two
same
persons doing the registration through the same mobile
No,
number?
Your Honor, let's see. The advertisement was for two separate posts. But this clause says that the person can apply for only one post.
So why were you why were you applying for the second post also?
No,
when
we are interested.
You can only apply only for one post, then why were you applying for the second post also?
No, we are eligible to apply for both the postulates. Exam will be conducted on different dates. That's
From where do you say all this? When the advertisement
let's
is...
see. Senior will assist you. Let's see better. We will keep for day after tomorrow.
I will not call for a counter affidavit in this case unless you satisfy me.
That is the policy, man. Laying down the policy.
Day after tomorrow.
Not day after tomorrow, next Tuesday it can be. We don't want to open a Pandora box on this. You could have applied, like there are so many advertisements that you can apply only in one district. Quite possible. What was the criteria of choosing both the posts? Different criteria was there?
Yes.
So your candidature in one has been accepted.
Yes, Your Honor.
You want to apply in the other. And suppose you are selected in both, then what will you do? And what will the respondents do?
You will choose.
Suppose you have a choice. What will the respondents do? Tell us. Suppose you are selected in both. You will give up one. Isn't it?
But they have accepted that we can apply for both the posts.
Where have they accepted?
Yes, let's see. In one of the case.
In one of the case.
WPC number.
There is a similar case also.
Yes, let's see.
Pending.
Yes. No, that has been disposed of.
Saying
With
what?
With their observation. WPC number 6368 of 2023.
Order दीजिए. WPC number 6368 of 23. This was in anticipation, before your candidature was actually considered.
Yes, it's in that case. But here our candidate.
They must have rejected this their candidature.
The last para, second page, you will see. Learned Counsel for the Jharkhand Staff Selection Commission on instruction submits that the apprehension of the petitioner is misconceived. As per Jharkhand Staff Selection Commission, the said clause 13(7) is applicable only in respect of an applicant who has filled up more than one form in one category. But we are trying to fill up the form on two different categories. They have accepted.
The learned counsel for the parties are present. Counsel for the petitioner seeks adjournment on the ground that his senior is not available to argue this case today. However, it is not in dispute that the last date for filling up the forms has already expired. The learned counsel has also submitted that, has also relied upon in order dated 17/1/2024, passed in WPC number 6368 of 2023, to submit that a submission was made by the Jharkhand Staff Selection Commission that clause 13 within bracket Roman 7 of the advertisement is applicable only in respect of an application who has filled up more than one form in only one category. And therefore the apprehension of the petitioner in WPC number 6368 of 2023 that his application form will be rejected was held to be misconceived. The learned counsel submits that the petitioner is eligible for both the post, for both the categories, this is an advertisement pursuant to the orders of this court. For both the categories, but while submitting the application under the second category was not being accepted.
Yes.
As he had earlier applied in first category.
Yes.
Post this case on आप काउंटर फाइल करेंगे? Let a counter affidavit be filed by the respondents by 20th of February 2024.
से ज़्यादा समय लिया ऑलरेडी
रिक्रूटमेंट प्रोसेस है ना, और धीरे धीरे और
नहीं ऑलरेडी डेट तो क्लोज हो चुका है
एग्जाम तो नहीं हुआ ना.
हाँ ठीक है 2 सप्ताह कम से कम दिया जाए कि इंस्ट्रक्शन दे
By 27 February 2024, post this case on 5th of March.
So let's see, liberty may be given to mention if the date of examination comes out.
I have already fixed a date. You can file an IPO.
Item 66, WPS 7362 of 2023.
Yes, petitioner.
The present petition has been filed with two full prayers. First, for grant of the benefit of ACP and MSCP to the petitioner, and second, for releasing the amount of gratuity which fell due after his superannuation on 31st of January 2020. What are the factual aspects of the case?
Any adverse order passed?
No, that is my specific.
Have you represented?
Because at Annexure 2 series, at page 30, series of representation, page 30 to 39 before.
Who is the person who will take care of your
Respondent
grievance?
number 1.
Who is the person who will take care of your grievance?
Respondent number 1.
Respondent number 1 will pass an order. The secretary.
Secretary.
Are you sure? The secretary will pass an order.
Actually, filing not the representation, my lords, if kindly have a look.
Has been filed before?
Annexure 2 series, page 30.
Before?
Starts from page 30.
Before?
Before Seva mein Pradhan Sachiv, Principal Secretary.
Okay. The learned counsel for the parties are present. District petition has been filed for the following relief. The learned counsel for the petitioner has submitted that no adverse order with regard to the claim of the petitioner has been passed by the respondent so far, and therefore the representation being pending, appropriate order be passed so that the respondent number 1 may pass appropriate order after granting an opportunity of hearing to the petitioner. Counsel for the respondents has submitted that no counter affidavit has been filed in the present case, but the grievance of the petitioner can be looked into by respondent number 1. After hearing the counsel for the parties and considering the nature of relief as prayed for by the petitioner, and also the submission of the petitioner that no adverse order has been passed against the petitioner with regard to the claim as prayed for in this petition, and the fact that the petitioner has filed representations but the grievance of the petitioner has not yet been redressed, this petition is disposed of, enabling the petitioner to file a representation before respondent number 1 within a period of 15 days from today, along with a copy of the records and all supporting documents. Upon thereafter, the respondent number 1 shall consider the grievance of the petitioner and call for the information from the concerned authorities and pass appropriate order after granting an opportunity of hearing to the petitioner within the period of 3 months from the date of receipt of the representation. If the petitioner is found entitled to any monetary benefit, appropriate steps be taken so that the same is remitted to the petitioner within a period of 6 months from the date of the reasoned order. Let the reasoned order be communicated to the petitioner through speed post. The respondent number 1 shall take care of all the applicable circulars, guidelines and other materials which may be applicable upon the petitioner, and this court has not gone into the merit or otherwise with regard to the claim of the petitioner.
Because may record my submission to the agent that he has not been granted regular promotion. He has been appointed way back in the year.
I will not record anything. Your writ petition will be there. You do whatever you have to say in your presentation. Yes.
Item 67, WPS 7588 of 2023.
Yes, petitioner. Rejected.
Petitioner is not appointed. Petitioner mother is working as Anganwadi Sevika and died during the service.
When? Date of death?
Page.
Date of death?
Date of death. 10/8/2020.
You have referred to them? Where is your representation? You are married or unmarried?
Unmarried.
Representation.
Representation. Page 49, annexure 7.
On 10/11/23 you file your representation, and on 23/12/23 you file the writ petition. Right? You don't even give them 1 month time. That too by post. 30 days will take to get them to assume delivery to them.
Appointment process is already been started, sir.
Appointment process has started.
First, appointment tool has been annexed by the petitioner at page number 53.
There is a provision for compassionate appointment also.
First, kindly see two provisions also. Page number 58 is relevant at para number 6, at clause number 6 also. Clause 6(2) कार्य में रहते हुए मृत्यु होने की स्थिति में आंगनवाड़ी सेविका सहायिका की एक आश्रिता का जो चयन की अन्य अर्हताएं पूर्ण करती हो चयन उक्त आंगनवाड़ी केंद्र के सेविका सहायिका के रूप में किया जाएगा. Thereafter also the eligibility has been prescribed in clause.
She is not eligible. How?
Page 54 also.
54. What is her qualification?
3 sub clause 3. आवेदिका पोषक क्षेत्र के गांव की बहू होनी चाहिए. अविवाहित लड़कियों का चयन इस पद के लिए नहीं किया जाएगा. His claim is that he is not married.
Yes.
She is not married.
My lordship, this criteria is not valid, my lordship. If how she will become dependent, if she is become married to someone else,
But
she
that
going to
clause
another
is
village.
that clause you have not challenged.
I challenge.
You have challenged that clause also as invalid. Where is that prayer?
Clause page 4B.
No. You have not challenged that clause.
Page 4 subclause B.
Page 4 subclause B. The respondent to immediately appoint the petitioner on the post.
For issuance of appropriate writ order direction.
The clause is not under challenge.
And moreover also as per her representation, it is mentioned that after the death of her mother, she has regularly been taking a part in the process of appointment also. So that at the same time they cannot claim both, either regular appointment or full compensation.
The learned counsel for the parties are present. Counsel for the petitioner submits that the petitioner is seeking compassionate appointment. Counsel for the respondents has submitted that the petitioner is not entitled for compassionate appointment in terms of the scheme, which disqualifies unmarried daughter from being considered as Anganwadi Sevika. You have filed your counter.
No.
Counsel for the respondents is directed to seek instruction and file a counter affidavit in the present case. Let the counter affidavit be filed by. It's a short counter affidavit. Right? You file shortly. Be filed by 20th February. Rejoinder by 27. Post on 5th of March. Since the under the heading for final disposal. You have not challenged that clause. That clause is not under challenge. Next
Amendment may be filed
Item 68
I
of
will not
case
allow you.
7616 of 2023.
Yes, petitioner.
Yes. Annexure 10 page it is impugned here.
File your counter. Counsel for the parties are present. Let the counter affidavit be filed by 27th February. Rejoinder by 5th March. Post on 12th of March. Under the heading for admission. Issue notice to respond number
5 and 6.
5 and 6. 5 and 6.
Actually, 5 and 6 are the ones who are basically power to either appoint or remove.
Okay, 5 and 6, for which requisites under speed post as well as already processed be filed by Friday.
It's a question of affiliated college, for where decisions are taken by the governing body.
Okay.
In this case also the decision has been taken by the governing body.
So you have no role to play?
That is my case, that university has no role to play so far as appointment and dismissal of service from an affiliated college is
Okay, the
concerned.
learned counsel for the respondents has submitted that the matter relates to affiliated college and the university has no role to play
Yes,
so
that
far
is the
as the
whole-
appointment and dismissal of the
Yes.
services are concerned. He submits that the matter primarily relates to relief against private
5 and 6, my
respondent.
lord.
Private respondent?
No, they are chairman, principal of the college and secretary.
Private
of the
respondent only?
Yes, private.
Private respondent. They have a remedy elsewhere?
I don't think, because this is the second round of litigation on the same issue.
Private respondent and has objected to maintainability of the writ petition. You filed your counter affidavit. We will decide as to whether in case of affiliated colleges where the state has no role to play.
I am not for state.
You are for the university. Therefore, the state also might not be having any role to play. Are you releasing fund for them?
Yes, they do.
They do?
Actually, what happens for affiliated college, my lord, the fund, part of grant is given by the state to the university.
To the
From
university.
Yes.
We'll take care. You just bring it on. The council for the state is also directed to seek instructions and file a counter
But
affidavit.
you say grant in aid is to given a university. So
We'll
that-
see that.
The state gives it to the university.
And university
University
gives us-
passes it on to the college.
What is the nature of grant, whether it is by way of salary or it is just a grant, these things you should bring it on record. Right? Defects? Defects देखते हैं, सबका same order कर देते हैं. Right? How much time do you need to remove the defects? You just tell us.
WS15 of the 2023.
I will pass one single order for all the defective petition.
3 weeks.
Just a moment. Today is 13th. I will give you time till 27th February.
Yes.
Sufficient? Everybody?
Yes. Milord, serial number 23, one defect needs to be ignored, Milord.
I will just उसको 23 को अलग करिए.
Serial number 24, because listed defect, it has been listed on a special bench fixed on 17th February for payment of dues in leadership. The dues has been paid in leadership.
It has become infructuous.
It seems.
If it has become infructuous, then we'll pass the order today itself. The matter is on the board.
The petitioner in leadership. She is the petitioner.
The case has become infructuous.
No.
This is the payment of the gratuity and the GPF amount, Your Lordship.
Your serial number is
24 leadership.
24 को अभी हटा दीजिए उसको straight away post कर दीजिए after 2 weeks. In the meantime, the petitioner may remove the surviving defects, right? It has been posted on 17th.
17th.
Okay. उसमें कोई order नहीं. The counsel for the respondents has submitted that the matter at serial number 24 is scheduled to be listed on 17th before the special bench. Let the office to verify and post accordingly. Right? Yes. For rest of the cases, except serial number 23. एक second अभी देखते हैं उसको निकालिए. In rest of the cases, time till 27th of February is granted to the petitioners to remove the surviving defects preemptory. If the defects are removed within the stipulated time, post these cases on 19th of March, right? 24. All these cases will come on 19th of March. Yes, 23. Which defect you want to be ignored?
Defect number 3, Milord. It is a rejection order of DC, Milord, and the stamp reporting has asked me to furnish a certified copy of that. It is merely a dismissal rejection order, Milord.
The counsel for the petitioner has submitted that the impute order has been passed by the deputy commissioner. But the office is asking the petitioner to file a certified copy. He submits that such defect be ignored.
I'll file the type copy.
He undertakes to file a typed copy of the same. type copy, so it is very much legible.
But still the stamp reporting is also pointed out the type copy. So there are,
The surviving defect in connection with filing of certified copy of impugned order is hereby ignored. The typed copy of annexure of the impugned order be filed by 27th February peremptory. If the defects, if the remaining defects be also removed by 27th, that is also peremptory, right? If the defects are removed within the stipulated time, post this case on 19th of March 24, consider appropriate.
Obliged.
Done?